Well, if there is a police report or a DHS report that suggests that the child or children are in surroundings that are harmful or endanger the child's safety, that report needs to be attached to that application for emergency custody. And if there's not a report present, or there's not a report that you have access to, and you're seeking the emergency application, you have to sign an affidavit, there needs to be an affidavit executed by someone who has direct and personal knowledge that the child is in an environment that is unsafe, that they're endangered, and that without the emergency custody order, the child would likely result, or that irreparable harm would likely result as a result of the risk. Recently had a case that involved our client, a father, had an emergency custody order entered against him based on the fact that he had an alleged problem with alcohol. The testimony in the case that was provided by the mother suggested that prior to the separation, he went to rehab, and there is no evidence whatsoever that he's had a drink since he got out of rehab many months ago. And yet the court still entered that emergency order against him. And it's unfortunate that in cases where there's no evidence of a real threat of harm to the children, parties are still put in a position where they don't get to see their kids. Maybe they have to see their kids with a supervisor present. That's added cost. It's less time with your children. And because of the way that courts operate, it's going to take longer and longer and longer in the case. And so it's an unfortunate fact that we deal with on a regular basis. So I just want to make sure that everyone understands what it takes. You have to be able to establish that imminent threat of harm if the order is not entered, whether DHS is involved, whether police reports are there, whatever the scenario, you always have to establish that there's an imminent threat of harm to the child if the emergency order is not entered.